Hello, 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 and good morning, everybody. Okay, I'm just going to get these documents ready. Good morning, sister. Sister. Good morning, everybody. Okay, so there was some documents filed over the last couple days, some that were just filed yesterday, late yesterday, so that's why I didn't get to them, but we're going to go over them quickly here. I'm not going to be on live very long, you guys, because I am working on getting another video together regarding this case. I feel like there is a lot of things that have been forgotten about. And I believe that these could be connections between Bryan Kohberger and Kaylee and Bryan Kohberger and Maddie. So we're going to go back over some of those things. I'm going to bring out some other things that we haven't heard yet, back from the very beginning day of this happening, stuff that is family, found on Kaylee's phone, stuff like that. I know specifically there are a couple of things here that I have found out recently. There's also a few things I want to go over that we touched on, but as the affidavit came out, we got more concerned about certain things in the affidavit and forgot these other points that I feel now are very important. There's one regarding Kaylee that I feel is extremely important to make a connection between Bryan Kohberger and one of these girls that their lives were taken. Is it enough? I don't know, but we're going to go over that. That's the video that I am working on. I was hoping to have it out already, but as I went looking for information, I just kept being drawn down other rabbit holes. So I've got like about 8 pages that I've written out, that I'm going to have to go through first and get everything in order so I can put it all into one video for you guys. Very interesting. When you go back to basics, it's very interesting on what you find. Lisa, good morning. George, good morning from Sydney, Australia. Wow. Welcome. Kate Bell, hello, hello. Salty Sleuth, hello and good morning. Stay-at-home mom detective, Merry Christmas. Yes, Merry Christmas to everybody. Don't forget also, I will be live Saturday morning for the mini reads. I have company for most of the weekend, so the only time I had free was Saturday morning. Sunday and Monday, I'm going to have a house full, so I want to say Merry Christmas to you guys. If you don't come into the live on Saturday, please have a very Merry Christmas and a wonderful and safe, happy New Year. So, with that being said, let's get into these new documents that have been filed in the Bryan Kohberger case. Okay, so here it is, you guys. Now, there's 2 filings because there was, hang on a sec. Today is Rose's birthday. Happy birthday, Rose. I hope she is doing well. You haven't let me know if you've gotten a hold of her yet, sister, so I hope she is doing well and recovering. Yes, please smash that like button on your way in. Okay, so there are 2 of these motions that the defense filed to try and get the indictment against Bryan Kohberger dropped, and they wanted a preliminary hearing. So this is the first one. I'm going to do this one first. She came home this morning. Surgery is scheduled for the 9th. Okay. Good morning, Babs. Long time no see. Good morning. Good morning. Okay, so we're going to go over this one. Public order denying motion to dismiss the indictment on grounds of biased grand jury, inadmissible evidence, lack of sufficient evidence, and prosecutorial misconduct. On August 23rd, Bryan Kohberger filed a motion to dismiss the indictment on grounds of biased grand jury, inadmissible evidence, lack of sufficient evidence, and prosecutorial misconduct in withholding exculpatory evidence. So everybody went crazy when this was in this here, withholding exculpatory evidence, when we seen that in their filings, when they filed this, right? But obviously for the judge to deny this, he has found that there was no exculpatory evidence there. So that's another big loss for Bryan Kohberger's team. On September 14th, the state filed an objection to the defendant's second motion to dismiss the indictment. On September 20th, 2023, Kohberger filed a reply to the state's objection. A hearing on the motion was held on October 26, 2023. Kohberger was represented by Ann Taylor, Jay Lodgden, and Eliza Massa. The state was represented by William Thompson Jr., Ashley Jennings, Jeff Nye, and Ingrid Beatty. This hearing was closed to the public and media cameras to protect the secrecy of the grand jury proceedings. Now, with doing this, you guys, being it closed, we're getting a little bit about what happened. This decision will also be sealed. However, the results of that decision are addressed in this public order for the public's benefit. So I believe the decision will also be sealed. His full decision is going to be sealed because he's probably going to touch on topics that the defense brought up regarding this withholding exculpatory evidence. And he's going to give his opinion on why that was not exculpatory, whatever that was. Okay? However, the results of that decision are addressed in this public order. Kohberger filed to successfully challenge the indictment on grounds of juror bias, lack of sufficient admissible evidence, or prosecutorial misconduct. Kohberger was indicted by an impartial grand jury who had sufficient admissible evidence to find probable cause to believe Kohberger committed the crimes allegedly by the state. Further, the state did not engage in prosecutorial misconduct in presenting their case to the jury. Okay, so what does this tell us? Hello, Jason. Good to see you on this side. Hello, Jason. I hope they do. I hope people stand all around that house so they can't demolish it. Oh, they're absolutely going to ask for a change of venue because Moscow is just too small, and they will probably get it. I can almost guarantee you they're going to get it. This is not going to be held in Moscow. Like Moscow is what? Population 20,000 or something? I don't know. I know it's not very big at all. So yes, it is going to be brought somewhere else. That's what I'm going to be bringing up in my next live. I've been trying to get this live together. I've been clipping stuff and finding stuff, and I just I got to stop with these people that are conspiracy theorists, because after I did the tunnel video that there are no tunnels, I got called out again. So it's just like I just got to ignore them and focus on bringing out what we know are facts. with the receipts. So trying to debunk a debunker. I debunked everything about those tunnels, and this clown went back at bam. There are tunnels. There were tunnels that actually, you guys, let's just on that one topic. There were tunnels that were put in and dug under the Idaho State University. There's pictures of it. And those are the pictures that this guy is showing on his lives, trying to convince people that there are these secret tunnels all under Moscow. It's not true. It's not true. And I brought the receipts on it. I'm going to touch a little bit about that in my full video, and I'm going to link to the actual person who brought all this out regarding the tunnels and where they go. They started building those tunnels mega years ago. They are all under the state of Idaho to carry steam. They heat with steam, right? That's why they're called the steam tunnels. So, Will is the best detective. There's only so much you can see on a screen. It doesn't allow a person to feel the environment, see the lighting, or hear. Exactly, Bob. Not only that, like I'm going to say, I'm going to touch on this in my next video. It's not going to be a live because it's going to be a little longer. I'm going to try and keep this one at about 30 minutes so I can get back working on that. There's a lot of things there, you guys, that I haven't brought out before that I'm now going to bring out. Some links to Bryan Kohberger and one of the girls. Links to at least Kaylee in Pullman. Yeah. So, and I'm going to bring you facts, not just pictures without showing you the full story regarding the picture. You know what I mean? Regarding these tunnels, he shows this picture of a tunnel being dug, and it says tunnels in Moscow, but he doesn't show the full news article on it. It's all under the Idaho State University, those tunnels, the pictures and everything that he was showing. It shows in that article that they are where they are, and they are under the university. They go nowhere near the 1122 King Road house. Nowhere near. I also brought out in my last video, if you haven't seen it, I will link it up top here at the end, where I show you the maps of all of that. I show you inside the bottom right bedroom where this guy is claiming that, look at that, there's a door handle. It's nothing but an electrical junction box. Boom. Anyway, I don't want to get in that again. It's irritating me. Anyway, let's get back to this. So, this tells us here that the judge also thinks that there was sufficient admissible evidence to find probable cause. Don't forget, for the judge to do this ruling, he had to go over all the evidence that the grand jury seen, etc. So if he feels what was presented to the grand jury was sufficient to find probable cause, the defense just got slapped. Everything they have tried, including bringing up laws back from the 1800s, did not help their case. They looked silly. I get it. I get it. They are trying everything to do what they can do to try and raise a reasonable doubt. I get it. But when you start saying things like it's beyond probable cause, the grand jury has to find beyond reasonable doubt. No, that's for a jury. Number one, that's why we have juries, or we could just forego all the jury trial It's up to a jury to find beyond reasonable doubt. 12 people have to agree beyond a reasonable doubt. That's why we have a trial and juries. That's not up for the grand jury. The grand jury is there to get an indictment or to say there's not enough for an indictment. The grand jury is there to get enough for probable cause to get an arrest warrant. Nothing more. They have to believe that there is enough evidence to find probable cause. End of story. If they were given the task of beyond a reasonable doubt, then there would be no need for a trial or a jury. Right? So, with that being said, the judge, after going over the whole grand jury transcripts and whatnot, has found that there was sufficient admissible evidence to find probable cause to believe that Kohberger committed the crimes alleged by the state. Further, the state did not engage in prosecutorial misconduct in presenting their case to the jury. Boom. There is a boom. Okay, so let's go on to the next one here. Now, this one here is order denying motion to dismiss. This is 13 pages. Okay. I don't think the defense will win. They can't prove Bryan wasn't there. The defense doesn't have to prove anything, Jason. That's the whole thing with this. They don't have to prove anything. All they have to do is raise some reasonable doubt, and they are going to extremes to try and do that. Now, if I was a Bryan Kohberger, I would love that. But being on the outside, I feel like it's wasted a lot of the court's time in the way they went about it, with going back to the 1800s and trying to fight for what the laws are now and what the role of justice is now. You can't compare back to the 1800s. We have evolved, right? But they tried. But it was a big waste of nothings. This law of probable cause has been here for mega years. You're not about to change that. So they don't have to prove anything. But what they do have to try and do is find something that can raise reasonable doubt. Oh, Alicia. And Salty Sleuth. Okay, so let's get on to this one. I am not going to read every single page here, you guys. Like I said, I want to keep it around 30 minutes here, so I'm not boring you, because the next thing filed was by the prosecution. They're done playing with the defense. Now they are putting their foot down and they want a date. So let's get through this one here very quickly. This is an order denying the motion to dismiss the indictment for inaccurate instructions to the grand jury. So the decision addresses the defendant's motion to dismiss the indictment for inaccurate instructions to the grand jury. The question of law posed to the court is whether the standard of proof for the grand jury to justify an indictment is probable cause or beyond a reasonable doubt. Based on history, case law, and Idaho criminal rules, specifically Rule 6 through 681 CR, the standard of proof for grand jury to indict is probable cause. Therefore, the motion is denied. Okay? So it just goes through here, procedural background, when he started filing all this stuff, all his motions that he filed, when they went to court on this. So I'm just going to scroll through it, you guys. So if you do want to go back and read it all, you can go back and watch the video once we're done, and you can pause it and read through all this. So I will scroll through it, and then we will go on to what the prosecution filed yesterday. And I love it. They're not messing around no more, you guys. They're done messing around. They're done playing. They're done with this 1956 justice, whatever happened, and citing these old cases. They're done. 1956 citations. I think they go back to 1889, the Idaho Constitutional Convention in 1889. It's just like this was craziness. And I feel like it wasted a lot of court time and money. Don't forget, the people of Idaho are paying for this craziness. And for the judge to have to write a 13-page reply, again, 1987, they went back in law like crazy, like as if things haven't evolved since the 1800s. Like 2011, unless it was precedent setting, it doesn't mean a thing. New precedents have been set since the 1800s, even since 2011. New precedents have been set that are now, gone by. And it was just pure craziness. See, 1985. New precedents have been set since then. Lucky Sunbird, hello. So I'm just going to scroll through this, you guys, and then we'll pick up with what was filed yesterday. Okay, so we're now at the conclusion. The arguments from defense for a beyond reasonable doubt standard for the grand jury were historically interesting and creative. He's throwing like a little dig. But do not overturn Idaho court's interpretation of the statute, the case law, and the criminal rules, specifically Rules 6 through 681CR, that the standard for the grand jury to indict is probable cause. Therefore, the court denies Kohberger's motion to dismiss the indictment based on his claim of inaccurate instructions to the grand jury in order to warrant an indictment. So there we go. We got that, right? It's like Lucky Sunbird, all the way from Australia too. I'm glad you caught us live too. So it's like, I feel personally, and you guys can let me know what you think. I think that, like Bryan, like I know when I was going through law school that we had to go right back into the 1800s with the British North American Act, and how, like you do go way back in history when you start studying law. And I think, and this is only my personal opinion, I feel like because Bryan is in the thick of that, like he's going through university and everything, to become whatever he wanted to become, because he applied to be a cop. There was talk of him wanting to be a lawyer. So we don't know. We don't know what he actually wanted to do with his degrees, but we do know that he applied to the police department, figuring that he knew better than them and he could show them ways to improve. Little narcissistic, don't you think? Anyway, getting back to this, I feel like because a lot of this textbook stuff is in his head, I feel like he pushed for this. There's nothing worse than having a client that has either studied a little bit of law or is still studying law. That's one of the worst clients to have because they think that they know better than somebody who's already got their degree and who has been studying stuff like this for many years and involved hands-on in courtrooms, everything. They seem to think that they know a little better on how things shall go. And if this is the case that Bryan is instructing his counsel, they pretty much have to follow what he wants unless it's something illegal, then they will not. But stuff like this, I feel this is coming from Bryan. I think he wanted to challenge the law, how it is today based on the 1800s and how our forefathers interpreted such statutes or whatever. I don't know. But I feel like this was a challenge for him. Like, oh, challenge accepted. It's not probable causes beyond a reasonable doubt. And I'm going to show you why. And I think that this was just something else he failed at. He failed a lot. And if you guys go back to my read, I will link it here to December 8th. Long before we knew that they even had a suspect in that would come out in that read. And long before we even knew Bryan Kohberger's name, long before, I just went over that read again. And the things that came out, even regarding him being some kind of somebody that gives lectures or teaches, that he's failed at everything, stuff like that, you're going to have to go back and check that read. That's long before we knew anything. Also, what came out in that read that I didn't remember was that they had found something that they needed time on. That was the sheath. But we didn't know that on December 8th when I did that read. We didn't know that until the end of December, beginning of January. This read was December 8th, and the date's on it. So I will link that read, you guys, in one of the top corners and in the description below. So you have to go back and kind of check that read out. It was spot on. It described Bryan Kohberger to almost a T before we even knew about Bryan Kohberger or even Bethany seeing him. This was like December 8th. So long before the probable cause affidavit, everything. Okay, so let's go on to what the prosecution filed yesterday. Like I said, they are not playing anymore. They're done. They're done with the antics of the defense. And I think there's a lot of people that are being kind of hard on Ann Taylor. Ann Taylor is a very good lawyer. But I think that she is being told by her client, Bryan Kohberger, on what he wants to fight and how it's going to be fought. She has no choice unless it's illegal. She has no choice but to follow what, especially somebody like Bryan, right? So prosecution is now fed up. This is a motion for the scheduling order. They are fed up. They want a court date set. Okay? They feel now that they have what they need. So comes now the state of Idaho by and through the Latah County Prosecuting Attorney's Office and respectfully moves the court for a scheduling order addressing without limitation the following. Scheduling a jury trial to run for approximately 6 weeks, and that's including the penalty phase. Okay? The state proposes that the court schedule trial for the summer of 2024. So that's 6 months, you guys. 6 months. and that the trial dates avoid times when Moscow High School and our area universities are in session. So I have those dates. Also, those dates are going to come in handy in my next video, right? Because a lot of people are saying, oh, Bryan didn't come to Pullman in June of 2022, right? Because graduation was in July of 22 back in Pennsylvania. You're not going to want to miss my next video on this, because I'm going to bring proof of a lot of things, including when Bryan Kohberger did certain things. I'm just going to leave it there. You guys are going to have to watch that next video. But they want to avoid the times when Moscow High School and area universities are in session. As the court is aware, Moscow High School is directly adjacent to the courthouse premises, and already the significantly increased amount of media and other vehicles related to this case has strained available parking as well as safety and convenience for pedestrians, including students. Now, the thing with this is, if the judge decides that they are going to have it, if nobody files for a change of venue and it's going to be held in Moscow, having it in the summer would probably be better when the schools were out. But if they are not going to have it during summer break, then that really doesn't carry much weight, because it's probably going to be moved, right? The court is also aware that when local universities are in session, it is not infrequent for area lodging to become unavailable due to university-related activities such as sporting events, graduation, etc. So what they're saying is, again, if it's held in Moscow, there's going to be a problem having it during school and university sessions, because when school is in session, because of local events and everything, where motel rooms and everything are booked solid for these things, and people that would like to attend the trial, for like family members, may not be able to get lodging, because lodging will not be available due to maybe a football game and people coming in from out of town for this football game. But again, this only applies if the trial is held in Moscow. If it's not held in Moscow, then this really is not an issue. It's moot. The state also requests that the court set a daily trial schedule from 8:30 a.m. to 3 p.m. So they don't want daily court in this trial going any longer than 3 p.m. And we know from other court cases that we have covered, sometimes we go until, on the East Coast here, we go sometimes till 7, 8 o'clock at night Eastern, which is usually 5 or 6 Central and Western time. So they want 8:30 a.m. to approximately 3 p.m. for a trial of this length. It is appropriate to afford jurors some amount of time to tend to their personal affairs. Usually what happens in this is they go from 9 till 5 or 6, but they take one day during the week off to give the jurors a business day during the week to be able to like go to the bank and do things that they need to do during the day. I think that is better than every day, Monday to Friday, 8:30 to 3. Because 3 o'clock, usually everybody's getting off of work. That's one of the busiest times, is after 3 p.m. till 5, 6 p.m. is one of the busiest times of the day. Just my opinion. Additionally, having more time in the afternoon allows for better preparation by the parties and allows for reasonable opportunities and time for the court and counsel to address any motions or other matters that routinely arise during the course of jury trials. The state's experience, this type of daily trial schedule is typically appreciated by jurors as well as court staff and counsel. It's like, I don't want to work till 5. I don't want to do 9 to 5. Well, they wouldn't want to deal with our court system here at all. It seems like a little whiny to me. Anyway, deadlines for completion of discovery for both the state and the defense. Okay, so this is what they want. They want a scheduling order addressing all these issues, okay? So the next issue is deadlines for completion of discovery for both the state and the defense. Deadlines for both parties to make expert disclosures pursuant to ICR 16B, 7, and C4. Deadlines for filing pretrial motions and responses and replies thereto, including but not limited to motions in limine, motions relating to the death penalty, and any motions under ICR 12B. Deadlines for jury questionnaire proposals, deadlines for proposed jury instructions, deadlines for proposed witnesses pursuant to ICR 16B, 6, and C3. Deadlines for Rule 404B notices, dates for pretrial motions to be heard, any other matters to facilitate the orderly progress of this case towards trial. They want to go to trial. The state notes that this court's August 22, 2023 scheduling order, the court set a date certain for sentencing disclosures, including witnesses, exhibits, expert reports, and any other evidence. The state requests that the court allow the parties further opportunity to supplement their disclosures following receipt and review of the opposing parties' initial disclosures. The court's August 22, 2023 scheduling order also directed the submission of trial exhibits and names of witnesses. The state again requests that the court afford the parties the opportunity to supplement those responses after they have had the opportunity to review and consider the initial submissions by the other party. Of the other party, sorry, not by. In its August 22, 2023 scheduling order, the court afforded the defendant an additional opportunity to provide a notice of alibi. Here we go, you guys. In accordance with the court rule and statute, the state submits that the defendant has already been afforded this opportunity and the court heard argument on the motions relating to such. The state submits the opportunity for the defendant to disclose an alibi and notify the state of the same has passed and asks the court not to reopen the issue. They want either you give us your alibi, give us places you were with proof you were there, or forget your alibi and it's not going to be revisited. There is no alibi. So that's what they're asking. They're asking that the court not reopen that issue. It would help in identifying dates and scheduling. The state would recommend that the court schedule a status conference on the record for the purpose of scheduling. So that's probably what we are going to see next. Unless the defense pulls a hissy fit over what the judge has ordered. We remember at the last hearing, he took certain things under advisement. He has now issued orders on that. I don't know if the defense is going to be up in arms. I'm sure they're going to come back with something. Good morning, Vera. But they want to get this scheduling done. They want a summer court date, trial date. They want this. Let's go. We do know that the defense has waived their right to a speedy trial, but the prosecution now is saying, okay, we want a court date and we want it in the summer of 2024. And because Bryan Kohberger waived his right to a speedy trial, it is now going to fall on the prosecution and the court to decide when this trial is going to happen. They no longer have to have it in a certain amount of time. So basically, it gives, figuratively speaking, gives the prosecution the opportunity to decide and convince the court to do it in a certain time frame. And they have chosen the summer of 2024. They say it's going to last approximately 6 weeks, including the penalty phase. There's a whole new, it's like, almost like a mini trial within a trial regarding the death penalty. So they say 6 weeks. And it's like, wow, okay. And on very short days, too, because they only want to go from 8:30, I think, until 3. Can they do it in 6 weeks? Let me know what you guys think in the comments below. So with that being said, you guys, I am going to wrap this up. I will be keeping an eye on the record. I am feeling a little bit better. Thank you so much, Vera. They've given me some medication to help to bring down the swelling and stuff. The major thing I'm still having a problem with is my tailbone. So it's very painful. I would never wish this on anybody. But these new meds, it's Celebrex. It's supposed to help with the pain because it reduces the swelling and stuff. I don't know. So I'm taking that and I'm taking Advil. So, and now I'm being told I can't take the Advil with the Celebrex. So I don't know. The Advil really did help with the pain. So I'm going to see today how this stuff goes. We'll see. But it is slowly getting better. They said 8 to 12 weeks. So it happened on December 6th, just 2 days after my birthday. So we'll see. We'll see. But thank you very much for hoping I feel better. Okay, so with that being said, you guys, I'm going to wrap this up. This is what we've got. Let's see what happens. Hopefully, as soon as the school is out, which I believe is June, they can have this trial. I'm hoping June, July. But let's see what the judge decides. I'm sure there'll be a hearing on this, so we'll have to wait and see. So with that being said, thank you guys for jumping on and going through this. Please watch for my next video where I am going to be bringing out some information that you guys may not have heard about yet, that may connect one of the girls to Bryan Kohberger. So with that being said, Saturday I will have the mini reads. So if you do want a mini read, please jump in 11:30 a.m. Eastern Saturday morning. We will be having the mini reads. Come and join us. Get your very own mini read. With that, hello, K Mitch. You two take care. So I will see you guys tomorrow. Tomorrow morning, 11:30 a.m. Eastern, right here for the live mini reads. And hopefully I will wrap up getting this video together. I want to be very precise on it so there's no mistakes, so nobody misunderstands what's being said. And then I'm going to ask you guys for your opinion on it, on what you think of the points that are going to be brought out. There is also a read that I've been asked to do on Katie Matthews. She's a young girl. I think like she looks young. She's been missing for a week or so or two now. So I've been asked to do an ancestor read on that. I know you guys love my ancestor reads. I'm going to try and do that now after this video is done. I'm going to try and get that ancestor read done and maybe posted later tonight. So watch for that also. Okay? So until the next time, you guys, please take care of yourself. Please stay safe. Always be aware of your surroundings. I love you guys to the moon and back. And don't forget, I will link my read that I did December 8th. Go read it. Go watch it, you guys, and see, compare that video long before we even had a name or even think that the police had a suspect and to what we know now. I will link it in the description below. Until next time, you guys, take care. Love you to the moon and back. Bye-bye for now.